Sir, this is a bill which naturally commands itself for acceptance by all right thinking men. The principle of recall is one of the fundamental principles of unfettered democracy, and it has been explained by facts and figures by the honorable mover of this bill that this principle should be incorporated in the constitution of our country. He has not expressed any hurry, so he has said that he is prepared to accept the verdict of the people and this bill be circulated for eliciting public opinion. As far as public opinion is concerned, we know that it is predominantly in favor of such an article being incorporated in our constitution because the public think that they are the masters of the land. But unfortunately, owing to certain constitutional difficulties, they do not have their say in matters of importance. Sir, our constitution naturally is not the final word in constitution thinking or constitution making. We are all familiar with the circumstances in which this constitution was framed, and when we talk about the farmers of the constitution, we do not have certain abstract personalities or ideas in our mind. We had a definite set of circumstances and a definite set of individuals who took upon themselves the framing of what is called the Indian Constitution today. In the course of 5 years of the working of this constitution, it has been found necessary, maybe for different reasons, and that this constitution had to be amended and changed. From the press, it appears that even the government of India now is thinking of amending Article 31. Therefore, experience goes to show that this constitution has got to be altered and changed, and so here is a bill the provision of which should find a place in the form of fundamental law as an article in the constitution. Sir, we have heard the speeches made from the Congress party. I can understand their anxiety when we bring up this measure, because if the provision for recall had been there in the constitution, the Congress benches would have been denuded of many honorable gentlemen who sit there today. The treasury benches would have been by now emptied if the provision of this article was there. We know all this thing, and it is quite understandable why these gentlemen, the great gentlemen who go by the Preventive Detention Act, are opposing this measure. Now, sir, we are not making it is a party issue. We are prepared to be recalled by the people. We would consider it a great honor to resign from parliament if the people demand of us that course of action, and I can tell you, as far as our party is concerned, we are not even bothered about the constitutional provision whether it is there or not. If, for instance, the people of Calcutta, the majority of the people of Calcutta, were to demand my resignation from this Rajya Sabha, I shall certainly bow my head to their will and resign from here whether there is a provision in the constitution or not. Similarly, I can tell you of the members of the other house that they will resign their seats if their constituents who returned them in the elections demanded their resignation. Recall, as far as we are concerned, is an article of faith. Whether there is a provision in the constitution or not, we will submit to the will of the people because their will is supreme and sovereign, and I think that nothing is to be more revered and respected than the will of the people. But the point is not that of what we feel and that we do not feel. The point is how you are dealing with the laws and with the constitution. That is the main point. The American Constitution required a certain number of amendments, and the Bill of Rights there came by way of amendments. 15 or 16 amendments were adopted in quick succession. Now, our Constitution too requires many more amendments in the right direction. This is one of the amendments that have been proposed. Now look at this parliament. I am dealing with parliament at the moment, not with the state legislatures. Look at this parliament and appraise its representative character. The gentlemen who sit there are honorable gentlemen, but they do not claim that they have been returned to this position of authority with the majority votes in the country. In the last general elections, they got only 44% of the votes, but the opposition parties between them got 56% of the votes. But the reflection of those votes is by no means here in this house or in the other house. They have monopolized those seats. That is how those people sit there with so few votes, and we come to have a few seats here. As I was saying, the main argument of the protagonists of this proposal was that there is a provision to this effect in the Soviet Constitution. Mr. Deputy Chairman, while moving this resolution, I would like to request the House and the government and the Prime Minister in particular not to take this resolution as one moved by this or that party, but as reflecting the feelings of our countrymen, at least of a very considerable section of our countrymen. Those feelings are reflected, if I may mention, in the resolution that was moved by the All India Congress Committee itself, and to cite another example in the statements of an eminent statesman like Rajaji. In fact, he has launched a campaign of our withdrawal from the Commonwealth. Now, sir, the Prime Minister himself has said in the Lok Sabha that because of the Anglo-French attack on Egypt, this question had to be considered afresh. It is today not only a question of sentiment or moral attitude or of our past attitude towards any association with the Britishers, but it is something more than that. Sir, if I borrow the phrase of the Prime Minister himself, we have to look at this question in a large perspective, the perspective of war and peace, though these factors also count as very important in the consideration of this matter. In the past, the whole stand of our national movement was for complete disassociation from the British Commonwealth. When that stand was reversed in 1949, the country was not given an adequate explanation as to why that stand was reversed. The Prime Minister certainly gave some explanations in the Constitution Assembly and in his public speeches. But the main point which he made was that many things had changed in the world and Britain had also changed. But there was nothing wrong if we associated with Britain as a sovereign country in the Commonwealth for purposes which may be to our Commonwealth good. Now, sir, recent events and particularly the Anglo-French aggression on Egypt have clearly demonstrated that the British imperialism has not changed. I do not mean the British people, but I mean the British imperialism, which has not changed at all. Events in Malaysia, events in Kenya, and events in South Africa were all clear pointers to the fact that the characteristic of the British imperialism has not changed, and it has not changed even now. We were told that we had been associating as equal partners in the British Commonwealth. While launching this adventure of aggression, the British government did not think it necessary to consult the government of India, or at least to consider the feelings of the government of India, which represented the feelings of the people of India. They did not have even that much courtesy. So where is the question of equality of status then? The bill, sir, which I have moved for the consideration of the House, mainly falls into four parts. As I have more than once pointed out in my speeches in connection with the First Amendment Act that was passed in 1952, the list that was prepared and appended to the original bill was done in a very haphazard way. In the First Amendment Act, an effort was made to correct some of the mistakes and to add a few more archaeological sites and monuments. In connection with that bill, sir, I had pointed out even then that there were quite a few monuments which were not included in that, even though they should have been immediately included therein. Hence, in the bill that I have put forth Here I have tried to include some additional monuments which should have been included there in even last time.